we've got Mr. John Oloide here with us. He's a legal practitioner. Thank you for coming on this morning.
Thank you.
Let's look at this. Help us shed light on this particular matter. It was yesterday. It was reported widely that there's this Federal High Court in Osun that had asked the National Assembly to, I think the Vanguard used the word, immediately begin impeachment proceedings against the president. Two gentlemen had gone to court. They say they had written to the National Assembly 3 months ago. They didn't listen, so they had to go to court. What's your interpretation of that particular, do you call it a judgment, an order, or what? It was an order of mandamus, by the way.
Well, it's not yet an order of mandamus.
Okay.
And that's the situation when news items don't get properly reported. I believe that, reading the report, I saw that the matter was adjourned to 30th October 2018 for further hearing. Now, if there was a final order, there will be no basis for coming back for further hearing. So what I believe has happened is, you see, when you are applying for a writ of mandamus, is to compel an authority to do its job as prescribed by law. So what I believe the two gentlemen have secured is an order granting leave to them to apply for a writ of mandamus to compel the National Assembly to begin impeachment proceedings. It's not as if they've gotten an order as of now. So the first step in a mandamus application is to seek leave. Usually in prerogative writs, you first of all apply to court that I want leave to be granted to me to apply to take this next step. The next step would then be to hear the application proper to apply for, to get a writ of mandamus issued. So that's why they will be going back on 30th October 2018. The National Assembly will be properly served. So it was out of place when the Minister for Information said, oh, I'm not aware of it.
Why? Because it's an ex parte motion?
It's an ex parte
motion. Or that he's
motion.
not a party to the matter?
The presidency will probably not be a party in the matter. It's about National Assembly. So the National Assembly will be the respondent. So they probably won't serve the presidency. And so when the order for granting leave now, the order granting leave to the gentlemen to apply for a writ of mandamus, when it is served on the National Assembly, the National Assembly will always have a right of hearing to say, look, yes, they told us to do this. These are the reasons why we can't do that. Now, after they bring their own position against the position of the men applying for a writ of mandamus, the court will then evaluate the two positions and come to a decision whether to actually issue the writ and order that the National Assembly should go ahead. So it's still incoherent. It's an ongoing process.
So when, let's just say the writ is issued, does that mean the National Assembly can go ahead now to begin the proceedings without necessarily finding grounds?
No.
Because in that ruling or in that application to the court, it wasn't stated exactly why they want the National Assembly to begin such proceedings.
Well, that's why I said it's in two phases. The first phase is to apply for leave. And then the next phase will be when the National Assembly will respond. The National Assembly doesn't have to respond. They could just not appear. You understand? In which case the court will say, okay, the facts that have been put before the court by the gentlemen, they have not been controverted. It doesn't still mean the court would grant the order. The court will still have to look at it properly and see whether indeed they have enough grounds to ask that the impeachment proceedings should be commenced. So when the order proper is made, then the National, if the order is issued, compelling the National Assembly to commence impeachment proceedings, then the National Assembly will have no other choice but to start in accordance with provisions of the Constitution.
That is, if the court thinks that they've got enough grounds.
That there are enough grounds.
So is it possible people will argue then that, no, you can't tell us how to do our jobs. We don't think that there are enough grounds. If there are, we will do it. After all, this is a political matter as well.
Yes, at this stage, that's what the National Assembly can do. They can go to court and say, no, you can't teach us how to do our job. As of now, all the grounds you have raised, they are not compelling enough for us to commence impeachment proceedings. But if they choose not to go, or they choose to contest it, and the court decides in its own wisdom that the grounds are compelling, the grounds that the people have raised are about killings here and there, certificate forgery, all sorts of things, and that the president has been nonchalant when he swore to the oath of office He said he will protect the lives of every Nigerian, and he has not done that.
Okay. If we move away from that a little bit and still talk about that word impeachment, for you, having looked through the Constitution, is it clearly defined for you? Because when was it that the former deputy governor, for instance, of Enugu State at the time, they said he was impeached because he had a poultry farm? People have all kinds of reasons. So is that word and the conditions clearly defined for you?
Well, the necessary conditions for impeachment are, to me, well defined by the Constitution. I mean, impeachment is serious business. It's not something that happens in any part of the world just like that. Now, there are impeachable offenses, which are very, I mean, when you do, for instance, revenue, for instance, there was an issue that was raised with the discussants before me about spending money that has not been properly appropriated by the legislature. Now, when that happens, that's a very serious offense. Now, when Nigeria, for instance, is under siege, that Nigeria is under siege, and it's obvious that the man at the helm of affairs is not capable or competent to protect the lives and properties of Nigerians, that's a very serious offense. When you have done something by way of infraction against a direct oath, the oath you took, oath of office, to protect the Constitution, any small infraction of the Constitution, for instance, relating to fair hearing, and it's open to you as a president, and you have the wherewithal under the law to ensure that that does not happen, and you don't do anything about it, that's an infraction, a constitutional infraction. So essentially, I'm not talking of poultry business issues. I mean, if for instance, the poultry business was set up through graft, stolen funds, for instance, that's against the oath of office. Nobody swore an oath to steal money from the polity.
What if it was set up before you became into that office, and while you were in that office, you left it for other people to run, but it was still running?
There's nothing wrong with that. I don't think there's anything wrong with that. I mean, just like the former president, the Obasanjo farms. I mean, when he left, when he became president, there was a trust that was constituted to manage the farm business for him. They grew the business. There are issues today, people say a lot of things, but he did the right thing. In the US, you remember, there was an issue of, I mean, when most of their presidents, when they become president, they leave everything. They set up a trust over which they have no say, they have no control, so that there cannot be conflict of interest. That's another situation of impeachable offense, where you do something that directly brings you into conflict with provisions of the Constitution. For instance, you are a president or a governor, and you have a business, and you, in your capacity as chief executive officer, you are making sure that your business that you left is being properly fed from state coffers. That's an infraction that is impeachable.
Okay.